we always make sure we said so, but.
Yeah.
You okay, sir? How are you?
I am great, happy to see you.
It's good to
You didn't
see
get blown away last night, now did you?
Yeah, I went out and I looked around this morning, I was like, this isn't that, it wasn't that bad, the leftover, I had a couple plants going out, but nothing, no branches down. Well, I hadn't gone into the big garden,
I know, yeah.
but I always like to see the branches down over there, cause that means they won't come down during the hurricane.
Smart, yeah.
Negative ghost driver.
That's a positive perception.
Can't be speaking like that, Kristen.
The next one,
There is no next one.
the next one. There's always the next one.
I'm just trying to hold on another season.
Yes, sir. Oh, you're okay? You sure? That costs something. It never does. No, I had it fixed. It's 10 minutes to 4. It needs a new battery.
10 minutes to 4.
No kidding. Let's get out of here. It needs a new battery.
That's what I wanted to hear.
Let me turn it on. Okay. He'll be okay. Mary Jordan is gonna be. Cause somebody called him in the middle of the night last night. Well, yes, I did. I was freaking out, Christy. That's the right. It's actually her son is from his lady in the service, and he's so cute. She sent me a picture.
Tracy has about controlling, he comes up here on my plate, and I think absolutely that's part of the problem. You know, it's really important, he doesn't call. You don't call on that. That has to be something that also makes difference. Or the board can vote on it, but I think, also, him walking around.
Yes.
People hours is
Her son is.
it's distracting to the board and all that, and that's why, but he needs, Lisa needs to stay beyond these tables. And no going in that hallway.
Is everyone here this morning ready to go? It seems to be 10 minutes before 4 o'clock, so we've been here a while already. I call this meeting to order this morning. The Escambia County Competency Board regular meeting March 5th, 2025. Madam Secretary, do we have a quorum?
We're going to read the board rules first, real quick. That's item 2 on our agenda, and then we'll go into
It
the forum.
is
Yes, sir.
item number 2, and I skipped right
I
over it,
switched
didn't
it up for you. I put it on the
I?
agenda.
Messed me up.
So please silence all cell phones. If you wish to speak, please let the board secretary know in advance. Otherwise, raise your hand for the board chair to recognize your request. When the chairman calls you to speak, come to the podium, adjust the microphone, and state your name and address for the record. You are requested to keep your remarks brief and factual. Both parties of any issue will be granted uniform maximum time to speak. That's usually between 3 to 5 minutes. This hearing is considered quasi-judicial. Conduct is formal and profane or derogatory comments will not be tolerated. And yes, sir, Mr. Chairman, we do have a quorum with 7 members present. Miss Mary Jordan will be coming in a little late. She had something she had to attend this morning, but she will be arriving shortly.
Good deal. Thank you. Do we have proof of publication for our meeting today?
Yes, sir, Mr. Chairman, we do. It was published on Thursday, February 27th, 2025 in the Pensacola News Journal. And I believe the board council would like to make a statement.
I was just going to point out that when it comes to the order and the decorum in this room, you know, in the big boardroom downtown, we actually have something that separates you. It's in the bar or in the legal profession. It's beyond the bar. You can't come beyond that bar. And I was going to let you know that you have. I did notice that someone had gone in beyond these doors where they shouldn't have been, who's not an employee. I did notice last time I was here that someone kept coming up around where you are. That can be distracting. If they get beyond these tables, if someone's testifying, that can be distracting to the person that's testifying. So you may want to establish that beyond these tables, you have to have permission to approach. Even to go to the podium, you have to have permission to approach. And that will make things easier on the people that are testifying as well as the board members, because when someone starts getting into that, we would call the well, when they start getting into that well, it sets up a security issue that no one is in here to protect you from. So just to make you aware, and if that's your decision, that can be added into these rules.
I think the 2025 term would be they're getting in our bubble. But I think I understand the well.
Yes, I would like to say something.
Yes, ma'am.
And elaborate on that. It was a concern last month for me. It was very distracting. Not that anything was going to go on. However, I think we owe it to the citizens that are up here presenting their case to have our undivided attention. And I didn't have that as much as I should, because I was sitting there watching the person walk around and come up, as you say, in our bubble. So I do think something needs to be established on a security level.
And I appreciate you coming from that arena to think of that for us. And I would like to also establish with this, Ms. Christie, and I don't know do we do it separately or do we incorporate? I think the downtown also has a 3-minute limit on public forum.
Right, and that limit, as long as it's consistent across the board and it's not as to content, you can set the limit you want. So 3 minutes is fine, and I do believe that's what they use downtown. I can't remember, it's 2, no, it's 2 actually.
2 minutes.
For public forum, right. Thanks, Chris. Chris Schaefer is here, he's from our office as well. He's gonna take over because I have to get out of here.
Thank you, Ms. Chris.
Yes, so, and that can all be part of the minutes. Instead of her reading, part of the rules, she can read that in. No one is to come beyond the tables or to the podium unless called upon by the board. That can all be part of the rules.
And we would need to have in the form of a motion for that to be put into our thing, or do we just declare it?
You could do that if that's what you want, a 2-minute limit, and usually it's up to you because you're the chairperson. It's your job to maintain order and decorum. But if you want to make it an official part of the way you operate, you could just make a motion in the rule and make it a rule.
Okay.
So a 2-minute limit so you're saying a 2-minute limit, no one comes up to the podium or beyond these tables without being invited.
Without permission or
Yeah.
being invited, right? Do I have a motion for that before we,
I motion.
Second.
and I have a second? Any discussion from anyone before we vote? No discussion, all in favor, raise your right hand. All opposed, same sign. Seeing none, hearing none, motion is approved for no one to come past the table without asking for permission or being granted permission, and a 2-minute limit on public forum. Thank you. Thank you, Ms. Christie, for helping us with that.
Sure, I'm glad I can help when I can.
Good job.
Our next item is approval of the minutes. As you can see, attached to your agenda are the minutes, as well as some items that were viewed during the hearing that needed to be attached to the minutes.
Do I have a motion to accept the minutes as revised?
So moved.
Second.
All in favor, raise your right hand. All opposed, same sign. Seeing none, hearing none, motion is approved. And we did have proof of publication, is that correct? We did have proof of publication. I may have.
Yes, sir. Just to reiterate, it was published on Thursday, February 27th, 2025 in the Pensacola News Journal.
Gotcha, okay. Secretary, do we have anybody for public forum today?
No, sir. I have no sign-up sheets for public forum.
Okay, and do we have a status report from yourself?
At this time, I'm going to turn it over to Christy again. I think she has something that she would like to discuss with the board.
I'm gonna come up here so that, when you start throwing things at me, I can duck.
Good too.
So it came, when we were dealing with the MyTran hearing, it was mentioned by Mr. Hatler that he didn't think that we had jurisdiction over it. And I went back to my office and I did some research on the jurisdiction. I've had the opportunity to talk to a couple of you independently to let you know. I looked up the issue on the jurisdiction and I realized what had happened was that he had been on probation. I know we had talked about it, but he had been on probation until May. And once his probation ended, we lost that jurisdiction on him. So he made his payments up until April, and we had told the victim in that case that he needed to keep us aware if he wasn't making his payments so that we could get it on for the May. So as of April, he made his payment, but then of course in May, he stopped making his payments. After I researched that and after a discussion with Mr. Hatler about his client's situation, and I had a short discussion with our county attorney about this, I had concerns that we were beyond our abilities within that case. So I recommended, and I did speak to Mr. Lister, Chairman Lister, and I recommended that we not send out the order and give me, and what we have done is, what I recommend at this point is to withdraw the order and close that case with no findings as far as the restitution issue. So his license will not be revoked. What we have done is, you'll see down in probable cause, we have opened a new case, which there is specific statutory or code language on that would allow us to open another probable cause case for his non-payment of a judgment. We do have that judgment order, and we had to wait 90 days past that window of when the judgment order was issued. And so now we are within our window to open a new case against him for the non-payment. However, the limitations on your or what's available to you is going to be restricted to a fine. So I just wanted to make sure you're aware that that's what you're going to see change. I have to leave because I have to go to the canvassing board. We have another election coming. In case you're not aware, get ready. And so I have to leave, but I wanted to bring that to you and see if you had any questions for me. Mr. Hatler is here in case you have any questions for him.
Does everybody understand the situation here? And thank you, Mr. Hatler, for communicating with our legal to pull ourselves together here. Any questions at all? Everybody understand what's going on here? So we don't even have to make a motion. This is just resolve of its own then, right? Because we really didn't have the jurisdiction to revoke license or whatever. So that's just null and void without an action from us?
I would recommend that you have a motion to withdraw the order and to close the case without findings on the restitution issue only.
Okay. So do you have a motion?
So I'll make a motion to withdraw without any findings.
Second.
On restitution only.
On restitution only.
And
There was a
have
second from Mr. Batchelor.
a second. Any questions? All in favor, raise your right hand. All opposed, same side. Seeing none here, the motion is approved to drop that then.
So being a strong believer in when you're the one that brings the problem, you're the one that should find the solution. We are working, I met with Jennifer and with Melissa, I'm sorry, Miss Reaver. We met on the cases that are going to be in front of you today. And one of the things that we did is what we discussed was when you come across a case, you only have that you not just look at the complaint that's in front of you, but you do what this board has been doing, which is looking and seeing how many permits are actually open on the individual. What's going on with those permits and what's their status. So today they took that opportunity, and you will see that in your backup, where in the probable cause hearing for Mr. Smith, that they actually took it and put it into your backup. My recommendation is to ask the board, do you want them to bring those as additional counts when they do these, when they find that there is not a new complaint, but to reach out and start an investigation involving all the properties in which an improper permit has been pulled, not closed, it's past its 6 months period when it should have already been, when there should have been, it's 6 months, right? 6 months when it should have somebody should have gone out and looked at the properties. So that's something you'll see in the backup, because we didn't just want to drop the bomb on someone. And I know I've had the opportunity to talk to a couple of you, but it'll give us the opportunity to avoid having situations where we have multiple cases coming in staggered, like we dealt with, as you recall, and some of you were here for the Banks and Lacoste hearings. If we had looked at it at the beginning and looked at every one of the permits from the beginning and started watching what was happening, we would have hopefully prevented some of the damage, or at least tried to prevent some of the damage that occurred, at least gotten the information out there to the public so they would have known what was happening. Hindsight's a great thing, but we can use it going forward. So that's up to the board if you want them to bring them as separate counts, or if you want them to just at least include it in the backup so you can make a decision. But you would have to have a second probable cause hearing if you decide we want all of these brought, unless you allow them to bring it at the first probable cause hearing.
So, do we have that authority, or does these complaints have to originate from a owner responding? Is there, from what I'm understanding, these are coming from existing permits that maybe the owner has not reached out to us yet, and we would be reaching to them?
So,
Is that kind of the method?
Well, the confusion has been that we don't generate complaints.
Right.
We don't start a complaint.
Right.
However, once we have a complaint in the office, it is the responsibility to investigate that complaint fully. And so when they find outstanding permits, when they're looking at that, much as you've been doing when you look at the evidence, well, what's still out there? This would be their, as long as it affects the public's health, safety, or welfare, it's something they could look at without
Okay.
having and it wouldn't be a new complaint. It would just be part of the investigation on that complaint. It would be additional
I
counts.
just don't want to get us in a situation where we're overreaching or overstepping what we should be doing, and somebody complain or even legally come against us and say, well, this homeowner did not even complain, and yet we went to them to get information, started a new complaint. I don't know where that technical
Well-
level is.
I think what they're saying is they don't want to go that far to reach out. They just want to know what's moving with those complaints, what's moving with those cases. We want to make sure they know what's
So
moving.
this would be an existing case then, not something new.
I think it's getting confused. I think what you're saying is, so in our past meetings, they pull up all the open permits and we're able to see all of the permits in real time, as opposed to having all the information already ready in the documentation for us. Correct me if I'm wrong.
So correct, Miss Melanie. The last couple of meetings, this board has requested during the meeting for this information to be provided, just to give you a bearing of
Right.
the permitting history. And that is what we are presenting today in one of these cases, so you can see just the permitting history on the forefront instead of during the meeting. And you have the ability to address that with the parties during the hearing.
Thank you for the clarification, because I thought in my mind that maybe we were reaching out to some of those previous owners that had open permits or abandoned permits to find out what the reason was, and I was afraid we might be overstepping.
And that's what I was saying. You would learn, you have two choices. You can learn about it in the first probable cause hearing, and when you see it, you can determine whether or not you think those need to be delved into, because perhaps you're seeing a seriousness of multiple, and then you would say, we need to bring a second probable cause hearing take a look at these and let us know if there's an investigation that needs to be open. We need a second.
It's a great idea. I just want to make sure we don't get out here and,
Right. And the other option was have them bring them all at the first one. But if you don't, and it sounds like to me you don't want them to bring them all at the first one. You want the opportunity to review what's out there and determine whether or not a second probable cause needs to be held on the open permits that are not being resolved. The questionable open permits.
So in essence, what we're bringing to you on the front end of these things is just a history, so you can see it at the forefront.
Good deal.
It is up to the board and how they wish to proceed with that information, but it does come up during investigation that this is out there and it does exist. And it's really to make the board aware of what we have.
So just for our board clarification, if we see that John Doe's got a dozen permits out there, looks like abandoned because they're over a year or however, no activity on it, do we have the ability, right, authority to ask for investigation at that point from us, or does this again have to originate from an owner? Because I don't want us to get ourselves in a...
This is not a situation where they're going to start looking at every contractor. This
No,
is
no.
a situation where you already have a complaint
Right.
open.
But once,
And the evidence shows that there may be other situations that aren't being dealt, that this may be, You cannot use the evidence for the purpose of determining whether or not they have violated the complaint that's in front of you. But if you see it and you see a pattern and you think that there's a problem, then you could request for the health, safety, and welfare of the public that they look into that as a second
I
investigation.
can see it being a great idea. I just want to make sure we're not, again, getting out of our,
I know there was confusion about that originally, but I will look at it again, and I'll be glad to come tell you if I'm wrong,
And-
as you can tell.
And we're asking for that information anyway, because anytime a case comes up, first thing I want to know is that, is that consistent? This is the first time? Has this happened before? And that gives us the ability to look and see if it's going to be habitual, and we can pretty well judge, I'm pretty sure, based on the violations or anything that's happened. Just it gives us a better scope and better understanding of the individual that's in front of us.
It also gives you the ability to talk to the person that's in front of you. While you cannot consider that for determining whether or not they violated, or it gives you the opportunity to talk to them and go, "We're aware of what's happening. Are you going to fix this? Don't make it come back like don't come back to see us."
That's right.
Like used to be said, and that gives them the opportunity to know that they're not operating in darkness. They don't have the cover they think they have, or maybe they don't know what they don't realize they have a problem. So it gives them also that opportunity to address to fix things that they weren't aware of. And often we've seen it when it's been an office worker or somebody they just had no idea what that was going on by somebody that was in their office, or somebody that was employed by them. And this helps to keep them aware, because if they're coming before us once, we don't ever want to see them again.
right.
And just to bring up a historical case that came before this board, we did receive communication from another department about a demolition contractor that didn't obtain a pre-demolition inspection. And during that investigation, it was noted that that occurred several times, and this board did address that.
I remember
And that demolition contractor did take care of those things. So in that instance, with that demolition contractor, it changed the course. And I think we're trying to be proactive.
I love it. I just want to make sure we're not going to lose our hide.
I have a question.
Yes, ma'am.
So the complainant doesn't have to come forward for us to look at it if it's already lumped in to a complaint, but the state of Florida would also be a victim, is that correct?
The state of Florida is not, I'm not sure what you're
Like
asking.
they would, we don't have to have a complainant to do something on that case if there's a violation of some type of, them not closing out the account or, permitting issue.
So in that instance, the complainant would become Escambia County, because it was our investigation that resulted in this data, and that could be possible violations. It wouldn't be a complainant per se as a citizen, but it would be Escambia County.
Okay, so statute would cover us if we looked at,
Our county ordinance and statute would.
okay. All right. Thank you.
Sure. And I'll double check all of that. I'm glad to have the questions, because sometimes when you ask them like that, I wasn't sure what you were asking me. And Jennifer's had a lot more time in this room than I have. Thank you.
Good.
Any other questions for me?
Everybody good?
Do we need to make a motion, or that just can be?
That's
pushed
fine.
through?
No, we
Okay.
just need to make sure that you are okay, if anybody had an objection with that approach. We certainly, you're the board, we're here to make sure that, we're here to serve you, and you're here to serve the public. And so we all want to make sure that we're moving forward on the same foot.
Well, y'all know I love information and historical knowledge, so I'm in.
Thank you.
Any other comments? Everything's good. Thank you. Thank you, Ms. Christie. Thank you. So we'll move now into our contractor applications, the A team.
Good morning, Board. Yes, the applicant appearing before you today is Mr. Mark Kaysen. Now, Mr. Mark, if you will, please come to the podium, state your name, address for the record.
I'm Mark Casson, live at 6256 Kirsten Drive in Pensacola.
Yes, Mr. Casson, I apologize about that. Mr. Casson, he is applying to qualify an additional entity for the business M&M Residential Solutions, LLC. He has provided us with all of the documentation needed for good standing. And staff is deferring to the board for denial or approval of the application.
Mr. Kassan, you want to talk to us, tell us anything, or you just,
I mean, we've just started a new partnership, and so I need to get the license appropriate with that business.
good deal.
Yeah.
So on your existing company, is there any outstanding issues with the county?
I'm sorry.
On the existing license that he's got, because it's qualifying an additional company to his license, so the original license, is there any issues, any outstanding?
No, sir, there are not.
No.
It's in good standing.
And the
Yes.
staff's recommendation is?
When it's qualifying an additional entity, we don't give recommendations. It's at the board's discretion.
Thank you.
Have anybody have any questions for Mr. Kassan? Okay, anybody ready for a vote? All in favor, raise your right hand. All opposed, same sign. Seeing none, hearing none, the motion's been approved.
Thank you.
Qualify. Thank you, Mr. Kassan.
Thank you.
Our next one,
Yes, sir. The next applicant appearing before you today is Mr. Williams Robbins III. Mr. Robbins, if you will, please come to the podium, state your name and address for the record.
William Robbins III. I live at 2003 Bainbridge Avenue, Pensacola, Florida, 32507.
Wonderful. Mr. Robbins is applying for the application to take the building contractor examination, and he appears before you today with 5 years, 7 months, and 7 days of experience. Mr. Robbins worked as president at Etheridge Construction under the supervision of Brent Etheridge, who holds an active license, CBC 1256239, since February 13th, 2008. Staff recommends approval for examination.
you want to tell us anything, Mr. Etheridge?
Well, Robbins, I worked for Mr. Etheridge.
Mr. Etheridge, I'm sorry.
Yes, sir, no,
Robbins.
you're fine. No, I'm just excited. It's a new chapter in my life. I want to be able to use the gifts that I have to give back to the community, so,
Good deal.
yes, sir.
Any questions? All in favor, raise your right hand. All opposed, same sign.
Motion to approve?
Have a motion to approve. Do I have a second?
Second.
All in favor, raise your right hand. All opposed, same sign. Seeing none, hearing none, motion's approved. I did not make a motion for the first one, I just realized. Can I have a motion for Mr. Kassan?
Motion to approve.
Do I have a second?
Second.
All in favor, raise your right hand. Thank you very much. I apologize for getting ahead of my own self.
Thank you.
Thank you, Mr. Robbins.
Thank you so
Not
much.
Mr. Etheridge. Got that part right. Next case?
Yes, sir. The next applicant that will be appearing in front of you today is Mr. James Cobb. And Mr. Cobb, if you will, please come to the podium, state your name and address for the record.
James Cobb, 9719 Bridlewood Road, Beulah, Florida, 32526.
All right, Mr. Cobb is applying for the application to take the doors, window, and siding examination, and he appears before you today with 5 years, 1 month, and 25 days of experience. Mr. Cobb worked as a manager at American Garage Door, LLC, under the supervision of Mr. Brian Webb, who holds an active license DWS 0058 since June 25, 2008. And staff recommends approval for examination.
Mr. Cobb, anything you want to tell us this morning?
No, sir, I'm just excited. I've been doing this for a little over 5 years, and I'm ready to advance my career, and just excited, yes, sir, I'd like to move forward.
Good deal.
Motion to approve?
I have a motion. Do I have a second?
Second.
I have a motion, second. All in favor, raise your right hand. All opposed, same sign. Seeing none, Mr. Cobb, you've been approved.
Thank you, sir.
Thank you,
Board.
ma'am. Good luck to you.
Chair, we are now going to move into our probable cause hearings, and as we go about this, you will see that there's a little bit of a different flow that we're going to provide to you. So just hang tight with us. I promise it's going to be a good thing. Okay. So our first item today is Brett Smith doing business as Apex Plumbing LLC, state registered license number RF 110678884, contractor competency board complaint number 25011 COM. It's in regard to Michael Dolezal, the homeowner complainant at 3400 West Lee Street, Pensacola, Florida 32505. Mr. Smith, are you present today? Thank you, sir. And Mr. Dolezal, are you present today? Thank you. At this time, I would like to have Mr. Smith and Mr. Dolezal, as well as our investigator, Ms. Reber, sworn in.
Okay, do you swear affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I swear.
At this time, I'm going to bring up the investigation report that was done by Ms. Reber. Ms. Reber, is this the investigative report resulting from a complaint that was filed?
Yes, it is.
And who filed that complaint?
Michael Dolezal,
And on what date was that complaint filed?
December 17th, 2025.
Is that investigative report what is displayed on the screen?
Yes, it is.
And what case number was assigned to that complaint?
The case number was 25011 COM.
And who was the complaint filed against?
Brett Smith, doing business as Apex Plumbing.
And is the address listed on the investigative report the address that was on file with Escambia County Building Services?
That is correct.
And what is that address, Ms. Reber?
The address on Mr. Smith's licensing card is 4707 Old Guernsey, Milton, Florida 32571.
Thank you. At this time, I'm going to bring up a copy of the notice for probable cause hearing. Ms. Reber, is this the notice of probable cause that was sent to the respondent?
Yes, it is.
And is that what is displayed on the screen?
Yes, it is.
That is Investigators Exhibit D that was attached to the agenda. The next item I'm going to bring up on the screen, Ms. Reber, can you tell me what that is?
That is proof of mailing certified, the notice to hearing.
So board, proper notice was sent to the respondent. Moving back to your investigation report. During your investigation, were you able to determine if any alleged violations occurred?
Yes, I was.
And what was that determination?
Code section 1837D15C, proceeding on any job without obtaining applicable local building department permits and/or inspections.
And Ms. Reber, what was your justification for that determination?
Respondent applied for permitting on October 17th, 2023, but has not been able to obtain the permit due to has not been able to obtain the permit due to failure to supply building services with a septic abandonment letter. Respondent began performing the work on approximately September 26, 2024.
And in your investigative report, I see that there is some supporting documentation. Can you take us through those one by one?
Yes, I can. Investigators Exhibit A is the respondent's permit application.
And is that what is displayed currently on the screen?
That is correct.
Okay.
Investigators Exhibit B is permit application comments.
And is that the item that's displayed on the screen now?
That is correct.
Okay.
I have complainants Exhibit A, complaint form.
And is that item displayed on the screen for the board?
That is correct.
Okay.
I have complainants Exhibit B, estimate to complainant from respondent dated September 5th, 2024, in the amount of $7,570.21.
And is that the item that's now displayed on the screen?
That is correct.
Okay.
Complainant's Exhibit C, proof of payment to respondent in the amount of $4,271.06.
And is that item displayed on the screen for the board?
That is correct.
Okay. Ms. Reber, if you wouldn't mind, I see that you have a synopsis as part of your investigative report. Can you take us through that?
I can. Complainant entered into an agreement with the respondent on September 5th, 2024, to perform a septic to sewer conversion. The total amount of the agreement was $7,570.21. Complainant paid the respondent $2,271.06 on September 18th, 2024, and $2,000 on September 26, 2024. Respondent submitted a permit application to Building Services on October 17th, 2024. At that time of application, the respondent's license was at an inactive status with our jurisdiction, and the application was returned until license was updated. On October 23rd, 2024, respondent resubmitted the application, which was returned a second time due to failure to submit fixture count. On October 30th, 2024, the application was resubmitted and returned a third time for failure to provide the required septic tank abandonment letter. Respondent did not provide a written response. However, I have communicated with him on several occasions. When the respondent was notified of the complaint filed, he reached out to advise he had lost his office staff and that he was trying to learn how to apply for permitting through My Government Online and applying for the abandonment permit through the health department. Respondent was given the information on how to contact MGO for assistance in applying for the permit. On December 19th, 2024, respondent advised that he was having Carter & Sons, a septic tank company, go pump the tank and apply for the abandonment letter. However, the septic company would not be able to start until January 2nd of 2025. Respondent stated he would then submit the abandonment letter and obtain the permit. Respondent contacted me after January 2nd, 2025 to advise he was still waiting on Carter & Sons. At that time, I let him know that as of January 1, 2025, the process for the septic abandonment was no longer handled through the state health department. It was now done through the Florida Department of Environmental Protection. I advised him that I expected it to be a longer process. During my investigation, I reviewed the respondent's permitting history with Escambia County, resulting in the respondent having 24 permits in a status of pending under review and 10 expired permits without inspections.
And Ms. Reber, just to bring back a statement that was provided earlier, when did the respondent perform the work?
Sorry, just 1 minute. Okay, the respondent. I do that. Oh, sorry. Respondent began performing the work on approximately September 26th, 2024. I apologize.
And your last statement during your summarization is that you reviewed the permitting history. Is that permitting history Investigators Exhibit C?
Yes, it is.
Is that the item that is displayed before the board?
Yes, it is.
At this time, staff would request that the items attached to the agenda as exhibits be moved into evidence.
So moved.
Have a second.
Second.
All in favor, raise your right hand. All opposed, same sign. Seeing none, hearing none, motion is approved.
That would conclude our presentation of this case. Both parties are present, if you would like to hear from the complainant and also the respondent.
Yes, ma'am. Mr. Dolezal, if you'd like to approach the podium, please, sir.
Good morning. My name is Mike Dolezal. I live at 1006 East Tahar Avenue. 3400 West Lee Street is a rental property that I own. In response to a letter I received from Escambia County, when the sewer system was installed along Lee Street, I contacted Apex Plumbing and asked them to do the install. And things sort of proceeded as Ms. Rember indicated in her review. I happen to like Mr. Smith, and I've seen some of the work that he's done. I'm happy with the work that he's done. I would like to see two things. I would like to see this project finished by him so I can move forward and sell this property. And the second thing I would like to see is the letter I received from Escambia County indicated if the work wasn't done by January 20th, there would be a $1,600 impact fee. I would like to see that impact fee waived in this particular case.
So, Mr. Dolezal, when you say Escambia County, is that ECUA that you're referencing? The utility provider for sewer?
ECUA sewer connectivity availability.
Yes, sir. That is actually a utility provider. It's Emerald Coast Utility Authority. It's not actually Escambia County. Yes, sir.
Okay.
Yes, sir. So that is actually something coming from the utility provider to you.
So I'd have to go to them to get a waiver.
That's right, sir. Yes, sir.
But you are welcome to refer them to us for information that
Support that.
Yes, sir, to support that, and we will try to provide that for you because the transition from the health department to DEP for septic tank is horrendous. I actually received an email back from the director this morning trying to get things straightened out, and that's a whole convoluted mess right now. So a lot of this is out of both Mr. Smith and Carter and Sons' hands. It really is. I'm not defending anybody. This is a fact that our whole industry is facing with. By Florida legislator, everything went on septic permits January 2nd from the Department of Health, which has been doing it for years, to the Department of Environmental Protection. Health Department, it appears in our local area, they're making a slow transition. Just on the other side of Tallahassee, all the way to our state line, is the first zone they're doing. They're trying us out, thank us, for being their guinea pig, and then they're going to transition the rest of the state after they work out the bugs with us. Very kind of them. And in the process of this, Department of Health, it appears, did very little the last 2 months or more of work on septic tanks, which create a backlog. When DEP did get it, their whole new system, and then now we've got, I think it was 50 something in Escambia County that was left rolled over. My whole statement is simply that it's been a real mess, and Mr. Fradley has been kind enough to communicate. We're actually trying to set up a Zoom meeting with a lot of local installers to help work through some of this mess, but it has been a nightmare. And ECUA, we would be happy to give any information to them concerning this little mess.
Appreciate that.
To help go with that fee. So.
That's all I have.
Okay. I appreciate it, Mr. Dolezal, and then we'll ask Mr. Smith if he would like to comment.
I actually have the.
Can you identify yourself just for the
I
record?
started. Brett Smith. I'm the owner of Apex Plumbing. I need to give you my address.
Sure.
All right, it's 5951 Pollard Drive. I actually didn't get any of the paper. I don't know if I was supposed to, but I have a record or pictures of we finally got it back from the septic tank company, or from Protection Services or whatever. The abandonment letter, we finally got it like 2 days ago. So,
Yeah, DEP.
yeah, I called him and Mr. Dolezal and told him that within a week we'd have it completed done. So about the time all this happening, we were in the transition of changing shops and changing our dispatch ladies. So I have a pretty good amount. I want to sit down like with an appointment with somebody to go over like all the permits we have open and with this and Santa Rosa County. Just because we have so many, that's the dispatcher, we weren't really looking over her very much with the permitting, and now we have a bunch of open things going on. But we are, you know, we've got all of our, you know, everything fixed up now and just moving forward.
Do you have a time frame when you could make Mr. Dolezal whole on his project?
Yeah, I'd give him about a week or so. So I would say by Wednesday, Thursday next week, we'd have it completely done.
Wednesday or Thursday of next week would
Yeah,
be
according to the
complete.
schedule, yeah.
So what about the proceeding without obtaining the local building permit? I understand the DEP's a nightmare. But what about the local part? What's the
So
justification?
I'm actually the one that dug out the sewer, like myself, with one of my crews. I somehow or another, I thought the permit was pulled already. We went ahead and jump started it, and then I mentioned to Marissa, she had no idea we had to have a septic tank letter before we could actually start the work. So I thought she had already got them to come out there and pump it. It didn't work. I went ahead and ran the sewer. I mean, it was all it's up to code and everything. It's just the paperwork is what held us up. So I mean, the work is up to code, put it in the right way. It's just the paperwork wasn't.
So the only reason you were not able to obtain a permit is because the DEP abandonment letter? Is that what you're telling me?
No, so this happened before the DEP stuff switched on January 1st.
Right.
But I thought with the transition of the company, transition of the dispatchers, between Morgan and Marissa, I thought his got pulled and it got lost in our system. And we usually were pretty good with our permitting stuff. I know I have like 24 open ones up there. It's because of a job that we let go. I mean, I know that's all besides the point, but that's what I want to get with somebody to clean up our board.
Anybody else have questions?
I think the part that confuses me is you not knowing that there wasn't a permit.
So I know that there was the permitting in the process, but she didn't know the abandonment letter is what it was. She didn't know. She had no idea that we had to get, and it was a separate thing. It wasn't like just a permitting office. It was the health department and the permitting office. She didn't know there was a two difference.
So then my question goes to Jennifer. So Jennifer, he needed a permit and the abandonment letter prior to doing work, or only the permit to do work and then the abandonment letter to complete?
So the permitting process for a septic to sewer conversion, you need a few things actually. To obtain the permit, you must first have the sewer tap number from ECUA, and then you must also have the abandonment letter from, at that time, it would have been Department of Health, and unfortunately, this spans over the time of a transition between two state departments. So before we could even issue a permit, we have to have those two things in hand. And so he applied for the permit, and I believe the application date was in October 17th, looks like, from the investigation report. And then there was communications back and forth of things that needed to still be submitted. And so that's where it stands now, and I'm really glad that you got the letter. You got it a little bit quicker than I would have anticipated that you did.
Right.
Because I've heard some stories of it not being very quick. So
It took a while.
and that was the only thing on this permit based on the commentary that was in a holding pattern, as we needed that to be able to issue this permit.
It has been a nightmare. we have a lot of builders that have projects that we can't get permits because we can't get the septic. So it is a frustrating thing.
Yes, sir.
Anybody else have comments, questions?
I have a question for Jennifer, and just for historical knowledge. For instance, the complainant has the fee from ECOA for $1,600, and if that's not his fault and it's actually the business, their neglect, could that fee be transferred to the business under this board?
So we are currently at the probable cause stage. Today is just to make a determination of whether you believe there's an alleged violation here, and whether you want to proceed to a disciplinary hearing. I think to answer your question is, should this proceed to a disciplinary hearing and the complainant had this out-of-pocket expense that was the responsibility or that resulted in the respondent not doing something, etc., that could be a possible request for restitution at that time. We are not at that phase yet. Today is just a determination of probable cause.
And I think to go with that, if I'm not mistaken, ECUA put like a deadline to get tied in. It's neither Mr. Dolezal nor Mr. Smith's problem, or whatever the word is, that this backup is happening, because this is unprecedented. I've been in business 40 years. I've got one personally been there for over 2 months. 2 of them. And that's insane. I got, can't start anything because of this. So this is neither Mr. Dolezal nor Mr. Smith's lack of doing their part because a state agency is messed up. Does that make sense?
It does. I was asking, like, in future cases, if
Right.
that could be, something that we could consider. And that, this kind of prompted my curiosity.
Sure.
Yeah, and it is something that is eligible in the disciplinary phase, not, in general. Anytime a complainant incurs damages or additional out-of-pocket expenses, that is something that is reviewed during disciplinary
If it's,
hearing.
and especially neglect of the contractor, that's the key.
If that should be the
That's the
case,
key,
yes.
neglect of the contractor, yeah.
Mhm.
Yeah.
Thank you.
In this case here, Chairman, would we, and Jennifer, would we be able to maybe continue this to the next meeting to see that he then makes his client whole, since he says that he's gonna do that on Wednesday or Thursday of
I
next
think
week?
that would definitely be an option to the board to have a continuance to make sure that Mr. Smith does take care of Mr. Dolezal in the next week and a half.
And also go through the list of permits that are outstanding.
Yes.
Give him enough time to go through it.
My staff can definitely assist with that and give you a rundown. And you did speak earlier about, some that you were no longer doing, cancellation forms for those, and it should clean those up easily.
That's like 19 of those.
Yes, sir.
So it's
Yes, sir.
All but one, yeah.
Do we need a motion to?
We would need a motion for continuance if somebody wants to so do that.
I'd like to make a motion to continue this case to the next hearing of next month.
I'll second that.
Okay, any questions? Have a motion and a second for continuance. All in favor, raise your right hand. All opposed, same sign. Seeing none, hearing none. Man, we're kicking a unanimous today.
Hey, Chair, if I could, Mr. Smith, has your address for your company
Yes, I was
changed?
about to ask who.
If you could please go get that updated with the licensing division of the department, and that way we can make sure that you are getting your proper notices,
Yeah, if it
okay?
wasn't up to him calling me, I would
Yes,
have known
sir.
this was happening.
Yes, sir. Appreciate it.
Thank you.
Appreciate you taking care of our citizens too, Mr. Smith. Thank you. Thank you, Mr. Dolezal.
All right, just resetting here. Our next item is My D-Tran, doing business as M&H Construction Services, LLC, state registered license number RG 291103-748. Contractor Competency Board Complaint Number 250213, COM. It's in regard to Lin Yang Lee doing business as Let's Meet Korean Barbecue, LLC. This is the complainant, 6235 North Davis Highway, Pensacola, Florida, 32504. Mr. Tran, I know, is not present, but he does have representation present with Mr. Hattler. And I do see that Mr. Lee is present. At this time, I'm going to have Mr. Lee sworn in, and just a reminder that Ms. Reber was previously sworn.
Yes, sir, can you raise your hand? Do you swear affirm the testimony about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I'm going to bring up the investigation report from Ms. Reber, and we're going to... Oh, go ahead, Mr. Hattler. Mhm.
Yes, sir. Thank you.
And I will let Mr. Lee speak for himself, but I think I may be able to save the board a little bit of time this morning because Mr. Lee, I and Mr. Lee's attorney have been in communication trying to, work this out agreeably. And Mr. Lee this morning suggested that maybe we continue this until next month's meeting to give the parties a chance to finalize the details of that agreement and that paperwork. So if Mr. Lee, would make that request of the board and the board would consider doing that, then we could probably get the board out of here earlier today by a few minutes. But I just wanted to put that out there before the whole presentation was made.
So you've been making contact with his attorney. There's a negotiation process, very active.
Yes, we spoke yesterday on the phone, and I believe that we have an agreement in principle. Again, we just need more time to, firm up the exact details, get the paperwork done, recorded, the mechanics of finalizing everything. I'm hopeful that everything is again, of a satisfactory resolution at this point. Just like, again, we have to,
Okay.
get the paperwork drawn up, executed, and recorded. So I would say by next month's meeting, I think we should be able to have everything done and then come back for the probable cause hearing and hopefully, have a happy ending to relate to you at that time.
Mr. Lee, would you like to address this?
Actually, just Lin Yang Lee, address will be 1029 Bellevue Trail, Pensacola, Florida 32514. Actually, my lawyer just called me last night, and really, and he told me his attorney just told to him he has some plan, but he need more time to figure out. But right now, this time he will put some lien on the two job on it. So he have the 2 building will be put my name on the lien, so he can make some like a payment after this job. After maybe those 2 houses, he must pay me and he can sell the house. So I think this time he tried to make something. But he just called me last night, so I don't know where I just talked to him this morning. So I think maybe we just continue and see what's going on. And he said he need only 1 month can figure out all the document and check the what's going on for those 2 property and put my name on it, do some document. I say it's okay. Yeah, it's better than nothing. Better than he didn't do anything, right? Yeah, so I say I gave him the last chance, maybe. Yeah, that's all I want to say.
So I know last time, I believe Mr. Hattler might have reached out to the other attorney the day before the meeting as well.
That's
So
right.
I kind of see a pattern with that and the continuing to happen. But of course, I'm more than happy to go with whatever you would like to do.
Yeah.
But I'm ready to proceed.
Anybody else have any comments? This has been ongoing for a good while. And it is very true that this last month we were sitting here and at the 11th hour, we had a thing and we continued and then we found out there were some things we were overstepped in, so we backed up, and this is a new complaint now, a new investigation. And I think the thing that sticks with most of us on the board is the fact that payments were stopped at the appropriate time to limit us from what we did. And along with that, no payments, no effort has been made to try to do anything since then until the last minutes, and then all at once it's a panic mode. And I have to say one thing, Mr. Hadler, of your client, this I got to get this job done to get money to pay this job. If you're very familiar with these cases, when we see that happening here, that is a big flag, because it's some type perhaps of a Ponzi, rob Peter, pay Paul scheme, that whenever I got to take money from this guy so I can pay this guy, and then now I owe him, and it becomes a web that we have seen get way out of hand. So I think that helps us to not feel as comfortable. I'm not trying to speak for everybody, just in the general thing of the board, our past experiences, is just that somebody gets hurt.
And I think almost to add to that too, not to interrupt you, but strategy is a word that comes to my mind as well. So.
Yes.
And I can address a couple of those points. First of all, we're all concerned about the type of situation you just described. And so, I am not of any impression that that's what's going on in this case. So, that's my, I guess, judgment based on, my involvement in this case. So I don't have that level of concern here. What is being proposed is not using money from one project to pay Mr. Lee, for issues related to his project. It's a secured interest in real property, and so it's going to be a lien just like a mortgage would be. And when the property is sold, and the seller gets the money, off the top of that, is the amounts that the parties agreed to with respect to Mr. Lee's secured interest on each property. So it's a good deal for Mr. Lee.
What's an estimated timeline on that?
I don't know exactly. My client says that once his permitting privileges are reinstated next month, because the 1-year probation on Mr. Tran's permitting privileges expires, I believe, April 9th. So presumably by a few days after that, he should be able to start pulling permits again. He said once he can get those projects going, he estimates about 4 to 5 months to complete. And so
Jennifer, is that after our next board meeting? April 9th, and then 4 to 5 days?
Our next board meeting is April 2nd, I believe.
Okay,
So April 9th
another
would be after that.
continuation.
Well, not necessarily, because if we can get the documents recorded before the next board meeting, then Mr. Lee and I will show up and represent that fact to the board to show that secured interests have been put in place to take care of the judgment satisfaction situation. And as far as any suggestion that I am gaming the system by waiting until the last minute to talk to somebody to come here and request a continuance, I just want to assure you that is not the case. I've been in regular contact regarding this issue with Mr. Lee's attorney throughout the past month. This is just not the type of thing that people instantly agree to. If you recall, last meeting, Mr. Lee rejected this offer. And so the offer and discussions only became enlivened again when I spoke with Ms. Hankins about the jurisdictional issue, and she realized that the board did not have the authority or jurisdiction to revoke the license. And I assume that when that fact was reported to Mr. Lee, he reconsidered whether our offer made sense. And so we have been working on that ever since that point.
But why were payments stopped in April?
Because he lost his permitting privileges and can no longer do work.
But if I recall, he didn't lose his permitting privileges. He could finish
He could
the
finish the
projects.
jobs he had, which means he still had an opportunity to bring money, which, yeah.
Correct.
And I think he had 1 or 2 jobs open that did get finished, and that's when he came back last summer to ask the board to reinstate his permitting privileges at that point.
Well, I hope you understand the reason why I say strategy here is that it's convenient, I guess is another word I would use, that payments were stopped in April. permits were still open so that he could continue to make money. So he definitely could continue to make money.
But he only
He
had
chose
one or two
not to make the
projects
payments.
open at that time, as far as I recall. And yes, that, admittedly, that looks bad. I'm not saying that doesn't look bad. He loses his permitting in April. He can't make payments in May. May is when this board lost jurisdiction, of the case. Yeah, that is certainly, not a good look, but I can tell you, with the benefit of hindsight, that was not in any way schemed, planned, intended, or even recognized.
So what we have before us, I'm pretty sure I'm correct, Ms. Jennifer can help make sure that I'm in line with this, but what we have before us is the probable cause. And if the probable cause goes forward to a disciplinary in April, we do have the ability to reach back into suspending privileges, revoke something with his license.
So
or-
we haven't given our presentation today in regard to the probable cause, and some of that is defined in the investigative report, and I think Christie touched on that earlier.
Right.
Because this probable cause is only relegated down to this one code section, and that comes with certain
Fines, yeah,
disciplinary actions.
right.
But in addition, correct me if I'm wrong, but isn't Mr. Tran licensed in other jurisdictions? So he had other places where he could make money than just Escambia County?
I don't know about his other jurisdiction registrations.
Can staff answer that for me?
So we do in his permitting, his licensing card, have where he did reciprocity to other, because we have to provide letters to those other jurisdictions. So I do know that he did reciprocate off the top of my head to Santa Rosa.
I think we need to determine as a board, are we following the money? Or are we following the actions that we took at the last board meeting? And now we've got another case in front of us because, for whatever reasons, whatever actions we took at the last meeting had to be vacated. So if we're satisfactory today with a payment structure that they work out, then we can continue. But if the goal of this board, a majority of it, is that we're still following through with the actions that we're gonna take, then I don't think wherever deal they work out should make a difference and prolong it. So I'm gonna throw that out there. Again, if we're chasing the money and if we're gonna be satisfied with the money being paid, or are we gonna take action on the license holder?
And I think with this too, this is a new case in front of us, and I'd like to hear the presentation.
That is correct. It is a new case.
Okay, thank you, Mr. Hazard. Let's go ahead and proceed forward if you don't mind, Ms. Jennifer. Ms.
Okay.
Reber.
Ms. Reber, is this your investigative report that is displayed on the screen before the board?
Yes, it is.
And there was a complaint filed. Who was that complainant?
Lin Yang Lee,
And what was the date of that complaint?
February 17th, 2025.
And what case number was assigned?
250213 COM.
And who was the complaint filed against?
My D. Tran, doing business as M&H Construction Services, LLC.
And during your investigation, were you able to determine whether any code violations existed? Or
Yes.
possible code violations?
Yes, I was. Code Section 1837D17, failure to satisfy a civil judgment obtained against the license or the business organization qualified by the licensee within a reasonable time. Per Florida statute, reasonable time shall mean 90 days following the entry of a civil judgment that is not appealed. The board will consider a mutually agreed upon payment plan by the contractor as satisfaction of such in a judgment, so long as the payments are current.
And what was your justification for that code section?
Tran has failed to satisfy a consent final judgment issued in the Circuit Court of Escambia County on October 8th, 2024.
And is there supporting documentation attached to the agenda?
Yes, there is.
Can you please take us through those items?
Investigators Exhibit D, Notice of Affidavit dated October 3rd, 2024, in support of default in payment.
And is that the item that is displayed on the screen for the board?
That is correct.
Mm-hmm.
Complainants Exhibit A, Consent Final Judgment dated October 8th, 2024, in the amount of $121,000.
And is that the item that is displayed before the board?
That is correct.
Can you please tell the board what is the address of record with building services for Mr. Tran?
1161 West 9.5 Mile Road, Pensacola, Florida, 32534.
And we were put on notice by the board that Mr. Tran had representation?
That is correct.
And is Investigators Exhibit B the notice of probable cause for today?
Yes, it is.
Is that what is displayed to the board on the screen?
Yes, it is.
And is Investigators Exhibit C proof of delivery to the representation for Mr. Tran?
That is correct.
Staff would request that items attached to the agenda be moved into evidence.
Do you have a motion?
So moved.
Second?
Second.
All in favor, raise your right hand. All opposed, same sign. Seeing none, hearing none, motion is approved.
And I see that you have a brief summary at the bottom of your investigative report. Can you please take us through that?
Yes, I can. This case stems from a case 220686 COM that was previously heard by this board. The parties reached a confidential settlement in civil court. The complainant notified the county that the terms of the settlement were not satisfied. Investigation resulted in a confirmation of default in payment of the judgment by the respondent. See Investigators Exhibit D, Notice of Affidavit, executed by the judge.
There is a typographical error there. There is a CE listed before that complaint number. That should not be there. That concludes the presentation of this case for us.
Okay, what's the thoughts of the board? Haven't heard all the information.
It's our option to move it to disciplinary hearing, is that?
Or dismiss, I guess. Or continuance, I guess we could do a continuance to see if they were, or go ahead and move it to a disciplinary.
I'm just not seeing what his license and what we do with his license has anything to do with the,
So,
yeah.
At the beginning of the meeting, Ms.
And
Christie.
I'm sorry I was
No, you're
late.
fine.
I
We're glad to hear.
apologize.
Glad to hear. At the beginning of the meeting, Ms. Christie mentioned that we actually were above our boundaries last meeting by doing what we did, revoking the license because of it being over the time period. So we rescinded what we did last month because it was not proper for us to do that. So we're back now with the new complaint. And the limit now, because this is a first offense, would be just a fine and not anything to do with the license. So we had to regroup.
Understand now, thank you for
That's it.
pointing out.
No, thank you for being here. So we basically can either move to disciplinary hearing, we can dismiss completely, or we can do a continuance to see if this situation will work out at the last hour again. That's our three. Is that right, Mr. Legal? Good.
I make a motion to move to disciplinary hearing.
Second.
Okay, we have a motion and a second to move to disciplinary hearing. Any discussions?
And, Chair, Ms. Melanie, would it be for the code violations cited within the investigative report?
Yes, I make a motion to move to disciplinary hearing for the violation against Code Section 1837 D17, a failure to satisfy a civil judgment obtained against the license or the business organization qualified by the licensee within a reasonable time.
Second.
Okay. All in favor, raise your right hand. All opposed, same sign. Seeing none, hearing none, motion is approved unanimously to move to disciplinary hearing. And it's still 10 till 4. We're almost finished. Any other business?
No, sir, there are no other agenda items.
Good deal. Anybody else have any business? Meeting's adjourned. Thank you.
Thank you.